Manever I say ma PENDREAM TV. PENDREAM TV there, osia dem yopo.
You are once again welcome to PENDREAM TV, the only channel that brings you the best and latest updates in politics. If you are new here, please don't forget to subscribe to the channel. Hit the notification bell for more updates. Like and also share to other members to watch as well. You can equally reach us on our WhatsApp number by voice notes. That's 0277-128-777. Thank you. Please do subscribe before leaving. We want your comments on this video that you are coming to watch or listen to, which is all about the Parliament and the Supreme Court, which FeameKpor has also reacted, and I want you to join me listening to what he said into detail. Thank you.
There were 5. 3 of them got approved. His and that of Justice Kumsin delayed until about January.
But they were voted upon by the appointment committee.
Yes.
And the appointment committee...
Yes, as for the appointment committee, they make their decision. They brought the recommendation to the floor. It is a plenary that out of the 5, 3 got approval. But that of the
appointment committee presented them to Parliament for approval.
Yeah, they recommend.
That is what I'm saying. They recommended all of them.
That's right.
Yes, and Senior here, who is an NDC member, is a member of the appointment committee.
No, I'm not. But I'll deal with those. No, I'm not.
Oh, you are not? Because Alfred said it, so I thought...
No, I'm not.
You are not what?
I'm a member of Parliament. So
okay, I thought he said the appointment committee. But the point I'm trying to make...
I'll go into the intricacies of that.
Yes, the point I'm trying to... Yes.
Let me... What happened was that, in that matter, somebody alleged that section clause 43 of the law that sought to limit the THC value of the narcotic content that's to be approved under the law was not properly debated. That was what the gentleman took to court. That it was Attorney General that sponsored the bill. So it wasn't about money. It was about how long it took Parliament. In fact, they actually deposed to the fact that that provision, that amendment was introduced at about 5:45, and by 5:50 it had been approved and adopted and formed part of the law.
Right.
And in the opinion of the plaintiff,
they were just making an intervention, so please make it brief.
Parliament ought to have debated the matter or even returned to the people, the representatives, to inquire more whether or not they were in favor. And when we were instructed, when it was struck down, and Parliament had to...
Please, let me bring in... No, don't draw him into this. He's an officer. He's an officer of the court. I beg you.
Given so predictable, you can't...
No. Resist that temptation. No, let me bring in Nelson Ross and FeameKpor on this matter. Being a member of Parliament who is a direct stakeholder in this matter, this is the decision of the Supreme Court, essentially dismissing the application by the Speaker. And I want us to hear the matter on the merit, the merits of the issue that the Speaker brought before the courts. This is what the decision of the court was, and I'll bring you on this point. Let's take a listen.
Application and find that the grounds supporting the application have no merit because of the very explicit and clear directions of the 1992 Constitution, specifically Article 2, Article 130, and Article 296, and established decisions of the Supreme Court from decades of the country's constitutional history.
FeameKpor, that's the verdict of the court.
To what? The verdict regarding what exactly?
That's basically the application by the Speaker, essentially.
You see, we need to understand how Parliament works. It appears that even the Supreme Court itself does not understand how Parliament functions.
Why do you say that?
Because if they have some appreciation of how Parliament functions, in issuing even the stay of execution order, they would have directed it to certain specific officers of Parliament, i.e. the Speaker, i.e. the Marshal, i.e. the Clerk to Parliament. Because this matter, let me reference Article 95 of the Constitution. It says, 95:1, there shall be a Speaker of Parliament who shall be elected by the members of Parliament from among persons who are members of Parliament or who are qualified to be elected as members of Parliament. 2, the sister provision in 97, here it goes, and then 95. 95:2 says, the Speaker shall vacate his office. A, if he becomes a Minister of State or a Deputy Minister. Do you understand what I'm saying? Or, if he resigns from office by writing, signed by him and addressed to the clerk to Parliament. Or, if any circumstances arise that if he were not Speaker, would disqualify him for election as Member of Parliament. Or D, if he is removed from office by a resolution of Parliament supported by the votes of no less than 3/4 of all members of Parliament. If you go to 97, 97 borrows this same similar language in respect of an office of a Member of Parliament. It says, a Member of Parliament shall vacate his seat in Parliament. Then it gives the indications. Now, what exactly is an issue here? What were the facts placed before the Supreme Court in this matter? Is the MPP saying that Cynthia Morrison hasn't filed as an independent candidate in Aguna West? Is that what they went to tell the Supreme Court? Did the MPP tell the Supreme Court that Kwadwo Asamoah did not file as an independent candidate?
Kwadwo Asante.
Kwadwo Asante didn't file as an independent candidate in Suhum. Was that the facts that the MPP brought before the court? Or that the current independent member of Parliament for Fomena has not joined them, the MPP, so much so that they have presented him and sponsored him as a member of the party under their logo, under their symbol, pursuant to Regulation 14 of CI 127, for which notices of poll have been issued to that effect? Are those the facts that the MPP presented before the court? So, what exactly is the Supreme Court trying to adjudicate? That these things have not happened? So, the pronouncement by Speaker should be stayed? It has taken effect. So, if there's a certain stay order, it will take Parliament to take that decision to reverse the effect of the Speaker's pronouncement. Parliament hasn't made those decisions. No resolution has been passed yet. Because the day that resolution could have been passed, we lack quorum to take that decision. So we are just in the Now, I heard Bobby say that the matter that went before the court was not political. Who says so?
Senior.
Okay.
I said it may have political implications.
No.
But we don't expect the Supreme Court to wear political hats.
It was not that it has political implications. Dafenyo Maki himself, now the minority leader who deposed to the Affidavit.
Now the minority leader.
He is.
He's the leader of the MPP.
No.
Okay, he says MPP caucus.
Let's not right to describe him as the minority leader.
Everybody should calm down.
Yes.
I am speaking to his own affidavit, so let me quote his own affidavit.
Okay.
If you go to paragraph, and permit me, because it will set the tone for this matter. Paragraph 8 of his affidavit, subparagraph 2, he starts by this way: that the ruling of the Speaker of Parliament deprives the 4 constituencies represented by these 4 ousted members of Parliament their constitutional right of representation in Parliament, because from the date of the said ruling up to the date of dissolution of the 8th Parliament of the 4th Republic in the midnight of 6 January 2025 is a period of less than 3 months. by the express provision of Article 1126 of the Constitution, 1992 Constitution, a by-election shall not be held within 3 months before the holding of a general election. Thus, the ruling of the Speaker of Parliament smacks of a coup d'etat. Speaker, the Supreme Court couldn't strike down this affidavit. They went to court to say that Speaker committed a coup d'etat in Parliament. The Supreme Court adopted this affidavit and acted on it. That one, it wasn't scandalous. To go to court and say that Speaker's decision amounted to a coup d'etat. The Supreme Court accepted this language in an affidavit.
You're reading from the affidavit?
Yes. And I'm referencing to paragraph 8, sub 2 of Apollo Markin's affidavit in support of the ex parte application. And that smacks of a coup d'etat against the 4 affected constituencies to deny them lawful representation in the National Assembly. 3. He continues. 3. That in the absence of any by-election between the date of the ruling of the Speaker of Parliament, that is 17th October 2024, and the dissolution of the 8th Parliament of the 4th Republic, Ghanaian citizens, listen, Ghanaian citizens residing in these 4 constituencies do not have the right of re-electing anyone to replace these 4 ousted members of Parliament. This makes the said ruling of the Speaker of Parliament, because I'm reading from, this makes the said ruling of the Speaker of Parliament an irreparable damage and excessively harsh if the said ruling is not stayed by this honorable court. You are listening to the terms of the affidavit in support. Pure politics. 4, this is where it comes, that the balance of convenience will tilt against the plaintiff applicant and the new patriotic party, the party in government, as the minority party takes over as majority party in Parliament. This will thwart government business, and by so doing make the country economically difficult in order to make the government of the day unpopular in an election year to score political points. Attached here to and marked as SBC is the weekly business agenda of Parliament for the week ending 18th October and all that.
Yes.
Now, the rest are our affidavits, I'll leave it. V885, paragraph 8, sub 5, that the ruling of the Speaker of Parliament, if made to stand, could plunge the country into mayhem and chaos as unnecessary parliamentary inquiries. Listen, as unnecessary parliamentary inquiries likely to be raised by the new majority party. Are you listening?
Yes.
By the new majority party in Parliament could bring government business to a halt and lead the country into civil disobedience, public demonstrations aimed at.
See, so the NDC was described as the new majority party.
Thank you.
In the affidavit.
So before the Supreme Court heard this ex parte application, they knew that it is the NDC that is in the majority in Parliament.
I see.
These were the facts placed before the court. So for anybody to say that what the court engaged in was not politics, then it leaves much to be desired. The court knew exactly what they were asked to do. Look, to file a process at 12:40 p.m. at the Supreme Court registry on a Friday afternoon, forget it. The registrar may not even be available. Yeah. Friday afternoon, Supreme Court. Do you know how the Supreme Court registry works? But to file a process at 12:40 p.m. and by 2 p.m. the court has given a decision.
I thought they started sitting at 2. Or
no. If you read the proceedings, by 2 p.m. the decision has been given. So from the time of filing,
It's unprecedented.
the alacrity and the speed is mind-blowing. Even the circumstances under which the registrar was able to inform the Chief Justice that an innocuous ex parte application has been filed that deserves our attention, for which 4 Supreme Court judges will be summoned and paneled, including the CJ herself, 5. And they will hear the matter expressly and determine it within 1 hour. Oh, my brother, we are all officers of the court. We know how the registries work. This appears well organized.
Well, the CJ's position is that this is a constitutional matter, not a political matter.
I am saying,
Really?
this is a political matter. I have just read affidavit in support of the application to you. So don't listen to what people say. Look at the documents that they considered. The CJ herself is also subject to the Constitution. The Supreme Court itself is also subject to the Constitution. Parliament is also subject to the Constitution. Are you aware there are constitutional provisions that Parliament can cite people for contempt of Parliament?
Contempt of Parliament.
Impede, when by your actions you impede the work of Parliament.
So with what the Supreme Court has done, is it a contempt of Parliament?
So Parliament should also cite the registrar of the Supreme Court, cite the applicant, the minority leader, cite the Supreme Court judges for impeding its work. You think that will have peace in this country? Maybe Parliament should do that.
Does their action amount to contempt of Parliament?
Why? That is what the applicant is saying. The person who is moving the motion on the floor of Parliament says that by the conduct of these persons, their actions seeks to impede Parliament from conducting its constitutional functions. And so they should be referred to the Privileges Committee. And let's see how things play out. So you see, the spirit and the letter of the 1992 Constitution engenders that these 3 organs of state are co-equal. They must peacefully coexist. The Supreme Court is not the supervisor of Parliament. With all due respect, it is not. It is not. I'm a lawyer and I know exactly what I'm saying. It is not. So the Supreme Court, some pronouncements, CJ will hold a press conference and say things that not even the president or the vice president can disobey. Yes, we know. But when a court order is disobeyed, we know the processes. Should we take the CJ to be issuing those threats that not even the president or the vice can disobey the orders of the court? Yes, we know. But orders of the court are disobeyed by even ordinary people. You go to court, you get an injunction, people continue to build. Nothing happens. If indeed, you see, it is not the speaker. It appears that the CJ is looking at the speaker like an individual. Speaker is Bagman is the occupant of the speaker's office as we speak. So her choice of words in addressing Speaker Bagman leaves much to be desired.
Number 2 or number 3?
It's number 3.
Number 3. Okay.
You understand? You are addressing.
But practically he's number 2.
Okay.
Yes. You are addressing another organ of state. So when you are addressing another organ of state, there must be some decorum. You understand? Look, you are supposed to coexist.
Senior, not to interject, but this line, I don't remember the CJ, or you are referring to her words in the ruling.
Yes.
Okay, so
if the speaker chooses. This is right. The speaker.
I was there.
Please.
So
please.
No, wait. No, but he has a right to interject. There was a right. He has a right to interject. He has a right to raise.
The tone was not conciliatory at all.
With all due respect.
He was talking down another arm of government.
Please.
Hold on.
I'm not saying it's not the same.
Gentlemen, hold on.
He was talking down another arm of government.
Hold on.
Please.
Hold on. What is the point of issue that you raised?
I am saying.
Bobby Banson. Wait. I just want to hear him. Gentlemen, yes.
Sorry. There was an issue that was raised in the application as to whether or not the orders or the rulings that were given by the speaker was even subject to the Supreme Court's intervention. It was clearly argued. Then the Supreme Court read the Article 2 that says that they can give directions and orders whilst they are exercising their jurisdiction to interpret the Constitution. And that the jurisdiction to give the orders, even if those orders are directed to any other organ of state, the Constitution says that if that organ of state disobeys those orders, it constitutes a high crime. So that ruling was in respect of an issue that had been raised. It wasn't as if the CJ or the Supreme Court, for that matter, just gave threats.
Part of what was said was even some commentary. But you see, it's not so much about the substance; it's the form in which it came. I think that's where Professor Jampo raises the concern. Now,
Now, can I make my point?
Yes, make your point. Make your point.
Now, when the Supreme Court says that if its orders are disobeyed by Parliament,
the president and the vice.
Yes,
and that is what the Constitution says.
Yes, and I'm saying that yes, it constitutes a high crime.
Yes.
So all the 275 members of Parliament will go through trial. High crime too will have to be tried. Won't we be tried?
Yes.
Yes. So it's such an unreasonable interpretation to reach.
Why?
Because it's not feasible. When Parliament decides to ignore this decision, nothing will happen. I'm telling you, nothing will happen.
It's just that there will be chaos.
Yes, but you understand, and I'm saying that I've just told you that if a member of Parliament decides today to cite the registrar of the Supreme Court for their conduct on the Friday that the ex parte decision was given, that the conduct constitutes contempt of Parliament, and so proceedings should be instituted. You think that there will be peace in this country? So I'm saying we must be reasonable when we are reaching some decisions, and we must imbibe the spirit and letter of the Constitution in reaching some of these decisions. And I'm saying that the evidence that Appenio went to place before the court is that Speaker's decision has rendered them a minority. So Supreme Court make us majority again. Essentially, this is what the affidavit is saying. And that the government of the day will be rendered unpopular. If this is pure, in fact, this is worse than a campaign, political campaign. And that the new majority will hold a lot of inquiries and it will render the government unpopular. Inquiries about what? Government's fictitious dealings. This is what the Affenyo Maki, as leader of the MPP caucus, went to tell the court. And the court tilted it. And you are saying that the NDC group in Parliament, as majority now, we shouldn't resist it. We'll resist it.
You resist it?
We'll resist it. We won't vote.
You will not vote.
Parliament must take a decision to give effect to this. We'll vote. It's my right to vote. I won't vote.
So, as Parliament is being recalled on November 7th,
yes,
you will go.
We will go. But we won't vote. There will not be a decisional quorum. I tell you. That one, mark my words. I tell you, on the 7th, there will not be a decisional quorum. There may be a commencement quorum. There will not be a decisional quorum. So nothing will happen on the 7th.
So the fundamental issue of who is majority has not been addressed.
It has not been addressed.
So with the recall of Parliament, that issue
will sit at our regular place.
Which is
for about 2 weeks now. We have a regular place we sit. That's what we sit. You see, we'll have to sit there for a decision, for a resolution to be passed to reverse the effect of Speaker's ruling. And that decision lies with Parliament. It doesn't lie with Speaker. That is the error the Supreme Court fell into. It is not the Speaker that will make that decision.
You mean it's not the Supreme Court that will make that decision?
No, it is not the Speaker that will make that decision. It is the House. That's why I'm saying they are failing to understand how Parliament functions. Parliament takes decisions by resolutions. And I say I won't participate in the resolution passing. It's my right to vote. I say I won't vote. If I don't vote, if all the NDC say we don't vote, there's no quorum to form a decision.
So that's what happened. That's why the Speaker adjourned the House Senate
yes. So the House will have to be adjourned again, and it will continue to be adjourned. Once he doesn't have a quorum to make that decision, he will adjourn, and he will continue. So this is the absurdity. This is the absurd consequences of what the Supreme Court has decided, that everybody appears not to have seen. This is the absurd, and the Constitution does not encourage absurd consequences for his interpretation at all. There must be purpose to the interpretation. I am saying the ex parte application that came, and Bobby, you made a point, but you see, procedurally, when you go to a court, you must direct the court the orders on no, not the reliefs. When you go to court, they'll ask you, what is your authority? So the authority must be indicated on the face of the motion paper. Yes. He did not. So the court now has to go and look for the law to support the application. That's what happened. You must say the ex parte application pursuant to Order 19 so of CI 47. Mm-hmm. That's what you do on the face of the motion paper. There was.
But we don't do that.
It is fatal. This is right. Wait. Hold on.
If you don't say that,
let him finish his point.
This is the Supreme Court.
He's making salient points. So we think that one he will allow, he will whittle down his point.
It is fatal. You don't go to the Supreme Court and ask the judges to look for the law.
Oh, yeah, but they will query you.
So make your point.
So I'm saying, even that, the Supreme Court has to look for the law to support the application. Okay. There are two.
Okay.
They pray for a stay pursuant to an ex parte application.
Right.
Which shouldn't last for more than 10 days. Supreme Court granted it ad infinitum. So they did things for the applicants that ordinarily any other applicant would have been through. In fact, you won't even last 1 second on your feet.
The crack is kernel for him.
You understand? So this matter is pure politics, and I've been saying it, that Supreme Court in any jurisdiction is a political organ. First and foremost, before adjudicatory, and this Supreme Court has shown exactly that. So for me, anything that goes to the Supreme Court, it has a political connotation for me. Every decision. We went to court in respect of e-levy. Tax. It's not been heard. It's not been determined. Till today, the matter is in abeyance.
I see.
I went to court. Let me tell you, the president woke up 14th of February this year and dismissed some number of ministers with the stroke of his pen.
Right.
Mentioned them, dismissed all of them. This is with immediate effect. So even some who were on their way to the office, they had to go back. One told me.
I see.
You understand? So hold on. And then, with the same communication, decided to make fresh appointments and sought to reshuffle 5 of those that he says he has dismissed. Mm-hmm. So I said, no way. He has the power to even reappoint them. But that reappointment, that reshuffle cannot be a reshuffle, because you have told the whole country that you've dismissed them with immediate effect. So the constitutional provision has come into effect, Article 79 or so. Mm-hmm. So they must be subject to parliamentary pre-approval. I went to court to therefore stay the hand of Parliament, not to vet the persons is brought. So the Supreme Court says, no, we can't stay the hand of Parliament. So those ministers, as we speak, they are working. The irreparable damage that will suffer is that tomorrow, when the decision is made, that the dismissal letter constitutes termination, and therefore any subsequent appointment of same people is subject to parliamentary approval, constitutional provision. The decisions they would have made on behalf of the Republic, what will happen to them?
So for you,
the court declare it null and void?
So the solution to this matter, in your view, doesn't lie with the court?
No, it's a political problem.
So how
that the court cannot solve. This is not a problem that a court can resolve. And the constitution is very clear on that. Unless, you see, the issues under 97(1), constitution is clear how you can stay in parliament when you join another party. It says, notwithstanding paragraphs G of clause 1 of this article, a measure of parties at the national level sanctioned by the party's constitution or membership of a coalition government of which his original party forms part shall not affect the status of any member of parliament. So the constitution itself knows that you can switch sides, but if you switch sides in a measure, you stay in parliament. But when you switch sides, you have to leave. And the constitution says a member of parliament, then people are saying that it is because it should be understood to be of a future effect. The constitution says a member of parliament. Go and check the definition of a member of parliament. A member of the current parliament.
Right. Well, the Speaker's verdict on this argument of whether or not this matter should have future consequence, the interpretation of this particular article should have future consequence. It says, quote, if Article 97(1)G and H were to apply only to future parliaments, they will be rendered superfluous. By the time the next parliament is constituted, any member of parliament who has defected or switched political allegiance during the current parliament will no longer be in violation of this provision. They will start the next session aligned with their new party or as an independent. Thus, there will be no defection and the violation will be wiped clean.
Thank you. Now, the constitution itself makes that provision. It provides for this scenario. It says a member of parliament shall vacate his seat in parliament upon dissolution of parliament. So when parliament is dissolved, you are gone. You are no longer a member of parliament. Automaticity. Nothing is. So I should also go to court and say that, oh, parliament has been dissolved. I'm no longer a member of parliament, but I don't understand, so I need interpretation. This.
Well, you align with those who say the language of 97(1) is
it's not about
1AG and
it's not about alignment.
It's clear in understanding.
See, unless the MPP is saying, no, the allegation that Cynthia Morrison is running as an independent candidate is not true. The allegation that Kwejua Asante is running as an independent candidate in Suhum is not true. The allegation that Fomina, the independent member and the second deputy speaker of the parliament, has joined the MPP is not true.
Okay.
Unless, you see, it is under these circumstances that you go to the Supreme Court to litigate this matter. But when the facts supporting the operation of this provision are uncontroverted, then what exactly are you looking for?
Okay.
Thank you for staying tuned. PENDREAM TV really appreciate your time. Please, if you have not yet subscribed to the channel, please do so for us. Hit the notification bell for more updates. Like and also share to other members to watch as well. Thank you. Stay tuned. We have more coming your way.
PENDREAM TV now, so far so good. Say open online portal e Ghana. Nipa share, nipa follow, nipa comment here. To my best of knowledge, without any biases, PENDREAM TV.